telling our panelists in the backstage, I'm a lawyer by profession, and it seems that law has changed very little, at least in terms of education, to adapt to the new technologies and to adapt to globalization. There's a big gap between what we study, the law studies, and what the world needs. So that's what they hear. They know that it's vital to reinvent legal education to bridge this gap. So we have a panel of lawyers. Be careful, guys. You know, lawyers in the room. Let me introduce them. We have our super moderator is no one else than the Dean of IE Law School. He's Javier de Cendra on your far left. Then we have the Secretary General, International Bar Association and partner of Gómez Acebo y Pombo. She's Almudena Arpón de Mendívil. We have the Dean of the Instituto Tecnológico Autónomo de México, is Jorge Cerdio. And we have the President of Law School Global Lead, Gonzalo Matias. Despite all speaking Spanish, they will conduct, I believe, this panel in English. Is that right? Now I'll ask a round of applause for our panel of lawyers. Thank you. All yours, Javier.
Thank you very much. Thanks to all of you for being here with us. And in this panel, we are going to discuss the challenges that face legal education and the legal professions. And I'm going to start off by being quite provocative so that we can quickly get into the real profound challenges that legal education is facing throughout the world and get also a bit of time to think about how to start addressing them. So I'm going to take a few minutes to elaborate an argument. Please bear with me. And what I'm going to do, for starters, is to come back to 2010 and reflect a little bit on the deep crisis that legal education has experienced in the United States of America. None of my colleagues come from the USA, so we can be safe about using that example and being trenchant about the USA. So 7 years ago, some very well experienced, very sharp lawyers in the USA decided to start filing lawsuits against law schools representing thousands, tens of thousands of students that felt cheated by the law schools. Why was that? Well, because they had been sold a future in terms of jobs and payment in those jobs that was unreal. Law schools have been promising students that upon graduation they will get fantastic salaries in the legal industry. Of course, that was not going to be the case. What did law schools do to lure students into the classrooms? Well, they inflated placement rates, for starters. They said that the percentage of law graduates that would go into lucrative legal professions would be much higher than it actually was. How did they do it? For instance, they hired their own students and they were saying to the market that those were in the legal profession making more money. Or they placed students in non-legal professions making little money and saying that they were actually in the legal profession making much more money. This was embellishment, a fraud and the consumer law protections. So the class actions went all the way to courts and to juries, and the real thing is that most cases they lost. Students lost. Why did they lose? Because the judges and the juries said that law students are sophisticated enough to understand that law schools cannot promise a job. Now, what was their argument? That they had become heavily indebted, sometimes paying more than 300,000 euros in tuition fees, and they found themselves without a job to pay back those loans, so they had important difficulties to find, to develop their own life. One of the deans of the schools that got sued by the citizens, upon being relieved of the lawsuit, said, "I am really happy because the jury has confirmed that my school is very committed with an education that guarantees students the knowledge, abilities, and tools necessary to succeed in the legal profession." Now, all this has had very important impacts on legal education in the USA. The number of students going into law schools, even the most prestigious ones, has gone down dramatically. Now, let me broaden now a little bit the framework in which these lawsuits took place. 2010, the midst of the global financial and economic crisis, many students that did not have a vocation to practice law went into law schools because they thought, we will have to pay a lot of money, but we will get very lucrative jobs. And law schools, knowing this, did two interesting things. One, to raise tuition fees to make more money. Second, to lower admission standards, to get in essentially anyone that wanted to study in their schools. Now, if this is the case, one would imagine, and this is what the literature has said, it has drawn two conclusions from this story, this little story about the class actions. First, once the global financial and economic crisis is finished, is over, law schools will come back to normal, and the legal industry will come back to normal. And also, the legal industry is being reorganized in such a way that is using technology massively to reduce the costs and to deliver more efficiently its services. And the law graduates, the law school graduates, were not ready to embrace technology, the technological disruption in the legal industry, because law schools were outdated. Now, this is correct, and the crisis has receded a little bit. But I want to suggest a deeper lesson from this story. Law schools, in my view, have fallen into a mercantilization problem, meaning they have forgotten what it means to be a lawyer, what it means to train lawyers. What is lawyer? It comes from advocatus, abogado in Spanish, avocato in Italian. Lawyers are those called to help others defending their legitimate cases through law. It's a vocation. And a vocation, there is no vocation to power, to prestige, or wealth. Those things are nice. They don't need to happen to be a happy lawyer. But many law schools have put vocation for sale. And many law school students have gone into law schools without a vocation to practice law because they thought law schools would give them a passport to wealth, power, and prestige. And when vocations are put up for sale, we can imagine the consequences. Lawyers very often pursuing power, wealth, by charging too many billing hours to their clients, finding contractual ways to extract too much rent from their clients' customers, exploiting young associates until they fall into despair, and generally bending legal rules of the legal system to their advantage. Some professors in the USA have gone as far as to say that the entire USA legal system is being manipulated to foster private ends. I'm going to come to my conclusions and then we start with the questions. First, legal education in the USA is still under this mercantilization trap. Second, law schools, if they want to get out of it, need to recover the idea of law as a vocation and spark in their students a love for the law and select those students that are really committed to promote the common good through the law. Third, they need to think deeply about the meaning of legal systems and the goals of legal systems and those that serve the legal systems. Last but not least, they need to adapt very quickly to serve the legal industry that is being transformed dramatically by technology and to enable serving many people that so far have been underserved by the legal system because of very high costs. So, we need to undertake a revolution in legal education, and that requires training lawyers that are technologically proficient, but also that recover the humanist approach to the law, recover the true vocation about the law. So what do you think about this? And what are the contours of the crisis in legal education, if there is indeed one, in other jurisdictions? Because this panel is about global legal education, not just the USA. Jorge.
Yes. I would say that you have described the perfect storm for not being an innovator in the US. Not only because they were assuring students a place in the legal services market, well-paid place, but also because law schools were happy and content with that. That is, they didn't innovate a single change in the traditional curricula. For example, the 1L, the first year of law schools in most US law schools has been untouched for the past 50 years or so. So they were placed in a position where they were not having the adequate incentives to innovate. So that said, for the US, I think pretty much spreads across Latin America. That is where Latin America top law schools provides somehow a mobility space for most law students that apply to a law school. So law schools are not incentivized to innovate in their curricula because they already are recognized by the markets. And I would say they translate or they move on the cost of not being innovators to law firms largely, where law firms has to take up young students, young graduates, who are not proficiently enough to engage into the new challenges of the legal profession, and yet the universities do not acknowledge that that's a cost that they are translated into legal firms. So I would say that Much of what you have just depicted for the US applies for top schools in Latin America. I would say that this presents an opportunity to look at the other way around. That is, if we continue law schools not to innovate into a curricula and to acknowledge that we have to add value in face of complexities in the legal profession, then we are going to face with mobility into different other fields. For example, we have seen at least in Mexico, but this is also true, I know, of Colombia and Chile and Argentina, that prospective students have switched from law to political science or economics. And that's said not so much because of the social mobility, but because they are just not enthusiastic enough as to how prominent the future is in the legal profession. They already seen that the legal trends in the salaries are coming down throughout Latin America. So I would say, to sum up, much of what you have just described is a position where the innovation does not come because they have been selling a product to the legal services market that is fair enough, has to be acknowledged as a product that gets well-paid salaries eventually. Plus, law schools have been conservative enough not to acknowledge how they are not training legal professionals well enough in the legal services market and translating these costs into law firms, basically. So I would say the crisis pretty much resembles what we have seen in Latin America.
Thank you very much. So, Gonzalo, as president of the Law Schools Global League, representing many top law schools all over the world, how do you think about other jurisdictions, or indeed the global level? Is this crisis of legal education present everywhere, and perhaps differently? What do you think about that?
Well, I think the crisis is really global, but I would prefer to put it as challenges more than crisis. And I would point basically 3 issues that I think contribute to that crisis, or are the major challenges of legal education and legal practice today. And maybe we then have some time to discuss some of them. So I would say the first one is globalization. It's a huge challenge for legal education and legal practice, because law, legal education and legal practice in the past used to be parochial. So we have a very parochial idea of law as something that is national, that is particular of each state. It used to, when we have discussions with friends, it used to be, well, you're a lawyer, you can only practice in your own country. You cannot do it globally. Well, that is not true anymore. So, and we know that, and at the Law Schools Global League, we foster that. So that's a clear idea that globalization is changing the practice of law. So we can no longer train lawyers in our law schools as if law was a parochial practice or a parochial science. That's the challenge of globalization. Second challenge is technology, because, and I hope we can further that a little bit, but just in a sentence. Also, we used to train lawyers in a very different perspective. So we would train lawyers as accumulating knowledge. We would accumulate knowledge in our students and then hand them over to the legal practice, and then they would practice all their lives based on that and on that accumulated knowledge. That's no longer the case, because now technology is challenging that. So the knowledge, the database that was in the brains of a lawyer now is much more powerful in a computer. So that completely changes the way we should train lawyers right now and for the future. The future lawyer is not someone that is accumulating knowledge, but is someone that must have very specific skills to actually work with the knowledge that is accumulated in databases. Third, and I hope to be able to come back to this. Third is, how do we reconcile all these challenges with ethics? Because there's a very important role of a lawyer anywhere, globally, which is to preserve justice and ethics behavior. So the lawyer everywhere is someone that collaborates with justice. And sometimes we have to tell our clients, that's not a way to go, because that's not the correct way to go. So when you replace lawyers by technology, there's a huge challenge here. And one of the questions, obviously, is, what's the role for human beings? This morning we were listening to that. What's the role left for human beings in this technological revolution? And ethics is definitely a role that can never be replaced by a machine because it's part of the human judgment. So again, it's a skill we have to train more and more our students and our lawyers, which is to be an ethical, a professional, and someone that cares about the way we conduct the profession.
We are going to come back to technology in a moment, but I want to ask you, Almudena, as Secretary General of an organization that represents 100,000 lawyers in the world and all the global law firms in the world and many other type of law firms, you receive law graduates from law schools from all over the world. What is your vision from that perspective about the capacity of law schools to raise up to the challenges that we are describing?
That's right. Well, I very much agreed with what has already been said. What we perceive what is perceived generally at law firms, not only at my law firm, is that there is a mismatch on the skills that are increasingly being required from lawyers and the training that they get at university. There is, of course, the issue of technology that is growing importance. So you need to understand the technology, and you need to also know how do you want to use that technology in order to take the best of it. Second, the value of knowing the law is now secondary because that's static, and because of globalization, technology, and the speed of changes, those laws are going to change. The essence of the law is going to remain, but the particular rules are going to be evolving. So basically, you need to train in having a very good mindset on the capacity of reasoning, in looking at a very complex legal environment because of this hyper-connected world. You just cannot look at the local system. The situations that are arising are more global. Just think of new financial instruments, or in terms of cybersecurity, privacy, etc. The solutions are global, so you need to have that global view, and we need lawyers to be trained in that matter. And of course, you need lawyers that may provide clients and may provide, I would say, more broadly, society with those other capacities that technology, that machines are not able to provide. And those are connected with the essential core values of human beings, the capacity of passion, of compassion, of course, a strong sense of ethics. At the end, there is a need of being able to react very quickly and with a sense of principle to some issues. The clients don't value the information. The value now is really on what is the addition that you are providing to that. The value of information now is zero. That is for the machines.
So we are going to get now into the intersection between law and technology. And I want, again, to be a bit provocative here. So we know that on the one hand, technology as a single biggest factor driving change in the legal industries, I think we can agree on that together with globalization, holds a lot of promise. Why is that? First of all, it promises to increase several times over the efficiency and effectiveness in the provision of legal services. And this can lead to the reduction of costs, the provision of legal costs, and also the reduction in costs may enable access to justice to many people that before didn't have access to the system. And we are seeing very innovative legal tech startups that are focusing on using technology to give access to legal information, access to public participation, access to the justice system through applications, mobile applications, for instance. Also, technology may allow law schools, especially those that are wealthy, to try out to develop new innovative methods of teaching that enable students to understand better law in context, in a global context. It also allows schools with less resources to have access instantaneously at a very low cost or for free to legal professors, law professors from all over the world, to get top content from other jurisdictions, thus enabling their students to study law from a comparative perspective, and so on and so forth. This is good, but on the other hand, technology may further drive the mercantilization of law. Let me give you an example. Very sophisticated global law firms employ very sophisticated lawyers that will work for very large technological corporations, intent of drafting mass agreements, if you want, adhesion agreements, that we sign very happily in order to get access to information in the web, for instance, or to participate in social networks without really understanding the implications of that. And those law firms know, and the technology companies know. We've heard before from Niall Ferguson about the global war on data, on the ownership on data, on the use of data to sell more products and more services. So, on the one hand, increased access to legal services, to education. On the other hand, clear risks that we are seeing very clearly at global level as well. What is your take, Almudena, on this?
Well, I think that technology indeed has a very positive, has a positive impact. But it, as always, it has to be played well. I mean, it is technology for us and not us for technology. So this means that in terms of legal education, you need to bring in the factor. You need to widen what is the focus that you are providing your students with. And if we go one step backwards, as I was thinking as you were talking, I think that, of course, technology allows for the appearance of new service providers. The law can be available for a broader spectrum of people, but that is, let's say, if I can say it that way, a secondary law. I think that we have to consider again what is the importance of law, because there are now many agents providing alternative legal services, very much supported on technology, but at the end we have to think again on the relevance of the law. And this is connected with what you were saying at the beginning, with the need of vocation. If we are able to realize that only with the law societies and people will continue developing, and that we need to do that globally so that there are no gaps because solutions will be global, that means that we need a new thinking by politicians, by all the stakeholders, by universities, by law firms in terms of the relevance of the law, because otherwise there is not going to be sufficient investment, the programs are not going to be modified. So I think that is a first thing, which is, I think, the counterbalance to the invasion of technology.
Great. That's very interesting, actually. Jorge, what do you think about what Almudena just said in the broader context of the pros and cons of technology?
I would put it that I agree in the sense that we have to rescue the value of the law, but let me perhaps switch the perspective now to the law school. That is, you're on the legal practices, right? But my business is to produce proficient, good lawyers, and at the end of the day, good citizens that would provide and will construct a better society through the law, right? But to get that, we need to be aware of the context. That is, how much disruptive technology will be within the next years. From the law school perspective, this means that you need to prepare your graduates at least for 3 different, I would say, tiers or levels of interacting with these disruptive changes. The first level will be merely to comprehend. That is, lawyers will need to have the capacity to provide regulation for future needs, for future context of technology. And in order for them to do that, they need to know the inner workings of technology. That is the same for mathematics or for biology or for physics. That is, lawyers need to know how things work at the technological level, right? The second level would be how to prevent or how to better prepare them for the substitution effect of the automatization process that will come to the profession. That is, for example, instead of thinking of preparing a lawyer for doing a due diligence in a merger and acquisition deal, perhaps we will need to train them into data mining and to how to better tune the vectors for e-discovery, right?
So you have to train in both.
I'm both, right. I mean, I'm not saying that you are not going to train them in due diligence. I'm saying that perhaps this is not the level of comprehending the technology, but using it, right? And the third level, which brings me back to the essence of law, would be to be, I would say, enablers of the social impact from an ethical perspective of technology, to produce legal, technologically oriented clinics, for example, where they can interact with data scientists and they can interact with IA scientists and produce technology that would enable a better access to justice, that will lower cost of the underprivileged in terms of access to justice. That is, to prepare them to know how technology can robust and make their communities more resilient to the changes that technology is producing. So I would say it's not a simplification to say that it's either go back to the course of law or to be aware of the pitfalls of technology. This is a bit more complex. We need as law schools to prepare them for a very uncertain future. And I would say this goes along these three steps that I've just proposed: comprehend, use, and to be an enabler of social resilience of technology in their communities.
Let me go to you, Gonzalo, but let me add a reflection on this very interesting exchange of ideas. So let's go to the global level. We have roughly 21,000 universities in the world, but we have many more law schools because some of them are not in universities. Only Mexico has more than 1,000 schools, Brazil has more than 1,000 law schools, India as well. How do we do this? Because this seems to be an important recipe to guarantee that lawyers do serve the legal system and to avoid law schools churning out law graduates that are unable to serve the legal system because they don't have the knowledge and the capacity to be successful in a highly complex, highly global economy. So let me ask you, what is your view about the gap between what is needed and what is now being provided generally? And is there a big gap also between different types of law schools? And what do you make of that gap?
Well, there I really see a crisis. So there I agree we have a crisis because law schools, legal education used to be a relatively inexpensive education, with the exception of the United States, where it is very expensive. In other places in the world, it's a relatively inexpensive education because it's seen to be a pencil and paper course. You just get a lawyer or a professor in front of a class and you teach. That's no longer the case. That completely changed because that kind of education will no longer fit the needs of the lawyer of the future. Legal education is much more complex these days. So it requires a great deal of technology and cutting-edge technology that only high-end law schools can acquire. So we cannot deal with that in low-end, in low-budget law schools. And also the kind of training that we provide in low-end law schools will be useless for the lawyer of the future. And in that sense, and coming back to what you said before, Javier, even in the United States, but certainly even more so in other jurisdictions, law students are feeling a bit deceived by law schools because they feel they were promised the world, they were promised magnificent jobs and access to the job market, and then they can't access it. It's certainly not their fault, but they were promised something that cannot be delivered because the world changed dramatically. So we have to understand, and here with the law schools we are involved with, but also the law firm, IBA, everyone involved in legal education, we have to understand that there was a complete shift in terms of legal education and in terms of what's required. For instance, we have to train our students globally. We cannot continue to train our students with a pen and pencil and a piece of paper just across the street. We need to send our students to the world, to have these exchange programs, to be trained overseas, to have intensive exposure to technology, to high-end technology. So that requires, obviously, a much more demanding legal education.
Yes.
So again, I think very interesting reflections, and let me press on that one. We have said that legal systems are becoming so intertwined that we start to see something that resembles to some extent a global legal system. And we can put quote marks there, but kind of global legal system in which all the jurisdictions are deeply intertwined. But then we see that the main providers of legal education are law schools, and they are very different. Not all of them are equal, and there are many. And obviously the schools that in principle one would think have the capacity to adapt to these complex times, to provide technological resources, are those in the most developed countries, whereas law schools in other developing countries cannot do it. So we might see a bias between the law graduates from very rich countries that will dominate global economy and lawyers that should be serving other countries do not just have access, or if they have access to wealthy law schools in wealthy countries, they will not come back. So this can create a lack of equilibrium, a fragmentation of the global legal system that should serve a global legal economy. And that can generate many problems. So I'm coming back to one issue you mentioned, Gonzalo, and I think this is the final issue we want to discuss and reflect carefully here. What needs to happen, in your view, to make sure that legal education improves to address these challenges, and does so at a global level at more or less the same path, so that we don't see enormous differences in the quality of those that should be protecting the legal system? And here we don't talk only about lawyers, we talk about legislators, we talk about judges, we talk about policymakers, many of which are lawyers. So what kind of coalition, what kind of pact, what kind of strategy could we follow to achieve this, thinking in the thousands of schools that are out there? Almudena.
Quite a challenge, but a very relevant one. And I think that point one, I go back to my comment on assuming the relevance of law and the relevance of training in law if you want to have healthy societies. So this has to be a global project, because if there are gaps in different jurisdictions, at the end of the day you will find human resources in some areas which are not utilized, and that may create unbalances and unfair situations. So first, awareness of the relevance of law. Second, using those institutions like the Law Schools Global League, like the IBA, International Bar Association, that can really have a global view. And for example, we have started a project jointly with the Law School Global League and also with the IE. This is a wonderful project, and it is really interesting, because what we want to produce is a blueprint on the model of the legal education globally. And for that purpose, we are studying what are the challenges and what is the way to respond to them. Going region by region, we will get the input for more than 420 law schools and universities in each jurisdiction, draw what is the common line, and then have an overall view that can be applied globally, and practical examples on how to implement that new model, that blueprint of legal education. That would be a first stage, because of course you have the model, and then you need to get that into practice. You have to walk the talk. And in order to do that, I think that we need to involve the different stakeholders that have a role to say in the legal profession. Of course, we need to involve the politicians, we need to involve the judiciary, we need to involve the academia, of course, we need to involve the law firms, and only in that manner I think that it will be possible that if there is awareness of the importance of this subject, there will be a sufficient interest and resources and practical means to put these down to earth.
Thanks a lot, Almudena, for that. And I want to use that reflection to test a little bit, and let me be provocative again, the practicality, the applicability of this kind of global solution. You are deans of law schools in different jurisdictions. What do you think are the challenges here to actually come up with a global blueprint that can really inspire change and make that change possible?
Right. I think that the challenges are, I would say, in two different directions, but they are self-reinforcement challenges. The first is to, even if you have a coalition, a global coalition, you need to identify very well who is going to be the interpreters and the enablers of the use of the technology that work and travel well across jurisdictions. Let me give you one example. If you look at how mature the e-discovery technology is in the US for e-discovery, one of the things that's been preventing the use of that technology in other jurisdictions is the erratic way of the production of public data in other jurisdictions. It's merely how courts quote each other. If you don't have a good data public access to public information, that technology will not work well in other jurisdictions. So you need to be careful about who is going to be the interpreter and the enabler of technologies across jurisdictions. Not because of the technology, but because of institutional set barriers. And the second dimension that I think is problematic is the idea of producing good examples that will work as benchmarks. You can, for example, say that you need to use whiteboards in classroom instead of the Socratic method. But people oftentimes will take that example and translate it in a very unsophisticated way. That is, you need to produce as a public good in this coalition good examples as to how to benchmark what counts as a successful implementation of each technology within the law education, right? So but this goes both ways. If you have a good enabler of the technology that takes into consideration different institutional barriers, then you need to produce a global repository of good examples that will work as benchmarks, right? So I think the two most difficult things to overcome would be how can we identify the good interpreters and enablers of global technology for multiple jurisdictions and good examples as benchmarks?
Yeah.
Right?
That creates many challenges. I can think of two immediately. Language barriers, of course, the legal system regulating access to that data and dissemination of the data, but also, and as important, resources.
Yeah.
The amount of resources you need to dedicate to creating, in the first place, these data sets and the technology that can make use of it in a smart way are, it seems to me, quite large. So this comes back to the kind of coalition that has to be created. How do you see, Gonzalo, that happening, the very real risk that what is urgently needed cannot be achieved in many jurisdictions because of lack of sheer resources?
Well, I think there are two ways of doing that, and these two ways must probably be combined. One is that leading law schools in the world these days are becoming global schools, global law schools, in the sense that they are not only training lawyers locally, but they are training lawyers for the world. So they have an increasingly international crowd, and lawyers from around the world come and attend classes there. So that's a fundamental mission of leading global schools, to train lawyers from all over the world and to disseminate the word and disseminate the knowledge. So I think that's an important part of our institutions, which is to train lawyers of other countries, and they can go back and disseminate that knowledge. But at the same time, obviously that's not enough. So leading law schools have another responsibility, which is to create or to help enhance local institutions that can replicate that model. And that's where the Law Schools Global League came in, and the project we have with IBA, which is actually to gather schools from all over the world, engage them in these projects, raise awareness of the importance of these topics, also by benchmarking, by comparing practices and having this blueprint that will show by data what's going on and what's necessary for law schools. And then by raising awareness, hopefully it will raise the bar, and we will have a set of institutions globally that understand the importance of changing legal education.
Can you already see some seeds of this change? Do you see areas in specific institutions that are already walking in that direction, that are finding coalitions, that are finding ways beyond what we have just discussed?
No, definitely. And I mean, if we look at the Law Schools Global League, for instance, and the project we are running with hundreds of schools globally, The Law Schools Global League now has members across the 5 continents, very relevant schools in Africa, for instance, in Latin America, in Asia. So we have a number of schools that are now playing the leading role in their own jurisdictions. Well, ITAM is definitely an example of that, IE, Católica, and many others that are playing regionally this important role and will definitely be drivers of change in their regions.
Well, I would love to keep going for a good while. It was such a pleasure, but I think we're just, we ran out of time. So I want to thank you a lot for this engaging debate and to the audience for staying with us and learning a little bit more about the challenges we grapple with as deans or as representatives of large global associations. Thank you so much to all.
Thank you.
Thank you. Thank you.
Thank you.
Gonzalo, Matias, thank you. Jorge, Cerdio, Almudena, Arpón de Mendívil y Javier de Cendra. Thank you so much.